Well, Henshaw again, your family local constitutional coop from California, and more good news out of Washington, D.C., where we rarely ever get any, at least until the last couple of months. And this involves the U.S. Supreme Court. And they just recently not decided the case, but the point is they didn't take the case at all. And this is a big indication here that they know what's going on. This has happened before when they started out 5 years ago. They started out to be a judicial court again. They did the same thing in a place called Texas v. California. And the same thing occurred with Alabama v. California in this term very recently, where Justices Thomas and Alito wrote what looked like a dissenting opinion from the court not taking the case. And this is a case that involved 18 states, 9 of them on each side. What does Article 3, Section 2 of the U.S. Constitution say? In all cases, a double L, in which a state shall be a party, the Supreme Court has original jurisdiction. There's nothing hard about this. A double L. What the justices are saying, and they're not doing it openly, but for those of us that get the real message, they know on that court there are no sovereign independent states remaining which were admitted into this union. All we have left are what you can prove are federal insular territorial possessions. And send me an email, youwinnincourt@gmail.com. You learn all about that and a whole lot of other related issues that go into it too. And that's why when you walk into quote unquote court and you run into a black robed bastard and other attorneys, every time you see one of those, you're not in a judicial court. But we have the right to be from day one. You're going to learn that. Send me an email, youwinnincourt@gmail.com. And that's a major big deal here for no states. That impacts all 6 articles of the Constitution. And you're going to learn that all of this BS emanates primarily from the non-existent 14th War Amendment. And you'll learn how to prove that amendment not only doesn't exist, right along with civil rights, trans rights, you name it. It never did. Contemporaneously ruled unconstitutional by the U.S. Supreme Court. And I'm convinced the current justices are well aware of that fact. It's simply not there, so we have to get there with the right status and standing and the right issues, and you'll learn how to do both. Send me an email, youwinnincourt@gmail.com, and we can take it up and go from there. And even the other side, just seeing these issues the way I do it, saying it with attitude and with authority. For example, when I say no states, I got a brief that you'll get with my moderately priced constitutional defense document package. 83 pages on admission of new states, includes 4 pages of authorities before you ever get to the text of the brief, and 58 decisions of the 9 old farts, otherwise known as the U.S. Supreme Court, many of which I can recall a cappella off the top of my head. This is what's going to settle your case quickly because, when the perps see this, they're not going to know what to do, and they're right. The only choice they have is to get their checkbook out and be damn lucky that's all they're doing. So it's just good news all the way around, exactly like it should be from the beginning, going back to 1787 to 1791. We have rights and corporations don't. It's as simple as that. And when you learn that one fact and what to do about it, that goes a long way to helping you, beat them every time out and teach your children, your posterity, how to do the same thing. That's how good it is and how exciting it is. And for more information, send me an email, youwinnincourt@gmail.com. Remember to subscribe, tell your friends, like videos, get the word out. The sooner we take action, the quicker we get these bastards off our backs. Thank you.